Good morning, everyone. Thank you for joining us today on our webinar regarding employment risks and exposures. We have the good fortune of having panelists from Insurance Office of America, or IOA, and Landegger, Verano, and Davis, and of course, PBO Advisory Group. A little bit about IOA. IOA is a full-service insurance agency. It was founded in 1988. And it focuses on making the complex simple for businesses. IOA is the fourth largest privately held insurance agency in the United States and is one of the fastest growing independent agencies and was named the National Underwriters Agency of the Year. From the very beginning, IOA's leadership formed the company not only to provide clients with insurance and risk management services, but also to serve the community in meaningful ways. IOA has more than 1,300 associates located in over 60 offices in the United States and the United Kingdom. We also have Landegger, Verano, and Davis joining us, and they are a team of California employment lawyers exclusively representing employers and business owners. The firm was founded by Alfred Landegger in 1979, who recognized that there was a tone and direction of laws impacting the balance of the employer-employee relationship. And simply stated, the firm provides their clients with high-quality, cost-effective legal representation in all aspects of labor and employment law. The firm is headquartered in Encino with 2 satellite offices in Southern California. And we have PBO Advisory Group, who provides outsourced HR and accounting services, as well as business advisory services and human capital consulting. We have over 60 consultants who are here to serve your business needs. And with that, I want to go into a little bit of a housekeeping. We will be recording this video, so that will give you the opportunity to really just sit back and enjoy, take notes, and we can send this to you after the webinar is over. Additionally, there's a little box in the functionality of the webinar where you can put questions in. This is very free form. We're going to be having a dialogue with the panelists. So any questions that come up, please pop them in the question area, and we'll make sure to get those answered by the panelists. And with that, I'd like to introduce this really incredible panel. I'm really excited today to have you all here. So I'd like to welcome Nicole Devine. And Nicole Devine is a consulting chief people officer at PBO Advisory Group, and she works closely with leadership teams to progressively align the HR objectives within any organization. She assists in building teams and partnerships to execute forward-thinking initiatives, analyze potential issues, and create solutions. Nicole has worked in a variety of industries, including manufacturing, logistics, consumer packaging, and executive placement. As a results-oriented HR leader, Nicole's experience puts an emphasis on building strong corporate culture, strategic planning, training and development, employee relations, risk management, and organizational design. And we have Malky with IOA. And Malky's passion lies in serving nonprofit organizations personally and professionally. Since joining Insurance Office of America in 2018, he has applied his enthusiasm for nonprofits to his book of business, partnering with his clients to tailor their coverage to their niche needs. Malky also works with clients in tech, real estate, manufacturing, and construction. Malky has had the opportunity to speak on a panel at a Plus event to share his expertise on exposures unique to nonprofits, as well as lead webinars regarding employment practices, liability insurance, and cyber coverage. In his free time, he serves on the board of one nonprofit and is an executive planning committee member of another. And last but not, oh no, we've got 2 more. Jeff. Jeff is a managing partner at IOA, and he specializes in risk transfer, risk financing, risk management, and makes substantial impact on the bottom line of his clients. Just Process focuses on a total cost of risk and building a custom insurance program back.
I can't hear Francesca.
Yeah, I think we lost her audio.
Yeah, Fran, we lost your audio.
Can't hear us either, I believe.
Let me give her a quick text message.
Well, she looks great.
Mhm.
Well, can you try giving her a call or something?
Sure.
Okay, I think she realizes now.
Sound check.
There you
go.
are.
You're back.
Oh my gosh, I am so sorry. Where did I lose you?
You're about to introduce Roxana.
Okay, so I'm going to hang up the phone. All right, so sorry for the technical difficulties. Okay, last but not least, Roxana Verano. Roxana represents management in all facets of employment and labor law, such as discrimination and harassment claims, wrongful termination, protected leaves of absences, wage and hour law, and labor negotiations. Her practice includes appearing in state court, federal court, and administrative agencies like the National Relations Board and the California Civil Rights Department. In addition to being a litigator, Roxana provides clients with ongoing legal advice, drafts employment contracts and human resource policies, and provides training to employees and upper management, including mandated sexual harassment avoidance training in English and in Spanish. So without further ado, we're going to launch into the webinar, and Malky and Jeff are going to tell us a little bit about what is employment practices liability insurance. You all hear EPLI a lot, but they're going to dig in and give us a little bit more information about what that really means. So with that, take it away.
Thank you, Fran. We'll go over the definition of EPLI, what it means, what it stands for, real briefly for those of you that are not familiar. It's basically, as stated, covers businesses against claims made by workers. And there's a myriad of claims that are typically covered under EPLI for defense and indemnity, including any type of harassment, discrimination, wrongful termination, failure to employ, failure to advance. There's a bunch of stuff. The big issue for a lot of California carriers is wage and hour. EPLI does not cover indemnity for wage and hour, but a lot of carriers do offer a defense sublimit for wage and hour. It's getting harder to find. The limits are eroding slowly over time, but it's still out there. It's available. Other exposures for EPLI are third-party exposures, meaning claims coming in from non-employees, vendors, contractors, third parties. Could be the delivery person that comes in on a regular basis, could be anybody at all that's not an employee. A little historical background on EPL. There used to be, way back in the days, doesn't exist anymore, but you could find some cover under a general liability policy. General liability policies back in the days used to be written very differently than they are now. It had, the mantra was basically, it's not excluded, it's covered. Fast forward to about 15 or so years ago, all GL carriers have a very specific EPL exclusion on their policy. So that's just a bit of a background of what EPLI is. From a coverage standpoint, it could be purchased as a standalone policy or part of a D&O or management liability policy, which includes D&O, EPLI, fiduciary, crime, and employed lawyers if that applies. Thank you. I think we lost you again, Fran.
Okay, sorry. It's going to be
there
one of those mornings. So with that, maybe we can go into a little bit more about what are some of the increasing employment risks and what we can do about them. Of course, there's employee practices liability insurance, but also operationalizing some of the things that we can do to protect ourselves and maintain good practices. So maybe Jeff, you could speak a little bit to that and some ideas about how we can do a good job of managing our risk.
I think managing your risk starts from the culture. I mean, you know, that's something I know Nicole's going to probably talk a lot about, but I think your culture, you know, when people call me a lot about them, when they have a potential claim, it typically is going to start with, I knew I shouldn't have hired that guy, or I knew I shouldn't have hired that gal. And it's like, you know, you got to trust your gut. You got to have strong practices in place to make sure that you are checking background checks, you know, doing like integrity testing. There's different tools out there to do that. Make sure that the people you're hiring are the, you know, because people can sound pretty good in an interview, you know, and a lot of people have a history of jumping from company to company to put in EPLI claims. You know, workers' comp claims typically will turn into a EPLI claim. So just having a good, strong hiring process and a strong culture is really the key. And then, you know, of course, having a lawyer that can be involved and have those different discrimination, harassment policies in place and actual training around those, so your team actually knows what to do and that it's important to your company.
So Nicole, maybe you can talk a little bit more about that in terms of processes in the interview and onboarding process to mitigate from the beginning. I know that a lot of folks say, you know, hire slowly to make sure that it's the right fit, which Jeff talked a little bit about.
Yeah, thank you, Fran, and thanks, Jeff, for table setting nicely. I appreciate it. So, you know, one of the things that we discuss a lot with our clients is the culture impact and really sort of understanding who you are in that space, and from a value perspective, understanding how to align not just what customers you bring on from a third party perspective, but also as it relates to your customer internally, which are your employees. How do you align value sets on both sides that align to actually reflect the values that your organization is trying to drive? And so that's really how you look at culture in that space. As it relates to specific inflection points within the employee life cycle, the first inflection point really will be setting the stage correctly, even with solid job descriptions, and understanding clarity of role and responsibility, and setting performance expectations, and again, just table setting correctly for the first inflection point of onboarding. And honestly, even understanding the distinction between a new prior hire process, which is really the compliance piece of the paperwork and all of that stuff, but also connecting with your teams, making sure that they feel connected to their teams, to the organization, and the onboarding piece, right? That piece is a lot longer journey, similar to if you were to onboard a customer. Same way you would onboard an employee, that journey should look the same. Thoughtful, careful, methodical, very well done. And so there are certain, you mentioned operationalizing, and we can go into this a lot more, but in terms of culture, I think in this distinctive point in that piece is that employees themselves, they feel culture the most, how we operationalize in a business. And so if our operations don't align to our values and they don't align to what we're talking about, and our walk is looking different than our talk, then how we operationalize that piece is what's felt day in and day out, and that's what creates the burnout piece. So simple, strong foundational settings for any company, understanding your thresholds when you get to 5 employees, 15 employees, just understanding very strong foundational is a really good way to start.
So Roxana, you know, in terms of policies and procedures, how can we look at, you know, setting really good policies to address or mitigate employment risks?
Right. And I cannot agree with Nicole more. I mean, communication with employees is the key to try to avoid having any kind of litigation or claims, and to have really happy employees working at your facility and giving you the best that they have. And part of that is not only, like Nicole mentioned, the job description should have very clear expectations, but also having the proper policies in place to communicate to employees what the expectations are. Aside from that, there are several policies that are required by law. So is it necessary for a small employer, let's say with 5 employees, to have an employee handbook? No, but they definitely need to have some policies that would include the ones that are required by law, and there's quite a few of them, as well as those policies that may not be required, but will provide you with a defense. For example, meal and rest period policies, okay? The law does not require you to have a policy in writing. However, if an employer finds itself with having to defend a class action, a wage and hour claim, we need that written policy to put on a defense, to show that the, excuse me, to show that the policy was communicated to the employees and that they were aware of the rights under the labor code. So there's 2 sets of policies that are required, the ones that are mandated by California law and the ones that would help you defend a claim when you have a claim. So policies are definitely very important. And again, it helps you communicate your culture, your requirements, your expectations to employees.
And
So
actually, can I just ask a
when
quick
you guys
question?
are underwriting potential policies, do the insurance companies request, you know, those policies to review them?
They don't request the actual policies, but they, in the application, whether it's a new business application or renewal application, they have a list. It's almost like a checklist. But do you have these certain policies and procedures in place? And you have to answer yes. If you answer no, you just won't get any quotes. They won't offer any quotes.
It is a good practice.
Too. You really have to have those things in place to be able to get the insurance.
Yeah, it's at that point.
And you'll be surprised.
In California.
I would say you'll be surprised how often I'll work with clients that, you know, new clients that have been in business for many, many years. And when I request a personal file, there's 2 documents in the file, right? The application and maybe the termination document. And I'm always have to educate them and say, no, you do need to have at the minimum what we call a new hire package or an onboarding package that has those policies that will protect you moving forward.
Yes, and so are you seeing, Roxana, multi-state now because of the pandemic and people kind of scattering?
Yes.
Does that complicate the policies? And
Yes, we've definitely seen that through during the pandemic. Many of our clients have had some of the employees move either to Texas, Arizona, or different states, and they continue to be employed by them. So we have to make sure that the policies are properly implemented. The good news for California is that if you comply with California, most likely you're complying with the other states. So because we have the stringent requirements in the United States, but still we still want to make sure that we are complying with those other state laws that they may have, especially concerning payroll and things like that, and we're able to help them with that.
Okay, very good. Very good.
And Roxana, can I just ask one question too specifically, because I know on the consulting side, what we see a lot is what we would consider almost the low-hanging fruit, which is the wage and hour claims, because they're the easiest to file for. They're have a really solid return on investment for those who file. And so having really solid technology in place, whether it's a human resource information system or whatever, payroll, whatever that looks like.
Mhm.
Are you seeing the same thing on your side? Because that's what we're seeing on our side.
Well, we're definitely seeing a huge and continuing increase in wage and hour class actions and PAGA matters. We probably, where we years ago, we used to have maybe 2 or 3 class actions a year. Now we get 2 or 3 every week, if not more. It's constant class actions. And you're right, for the reason that you just stated, they're very profitable for attorneys. Any settlement that they enter into, they're going to take 40–45% from the top. It doesn't really benefit, in my opinion, the employees. You know, the employees will get a small check for $50 or something like that, but it's really about a business model for the plaintiff's attorneys, and we see more and more plaintiff's attorneys getting into that area. And what I usually say, unfortunately, the only way to avoid a class action or a PAGA is 100% compliance with the labor code. There's no other way about it. And that requires really an active effort on the part of the employer to ensure that they're in compliance. And I understand, you know, many of my clients, they're business people. They're concerned about running a business, right? Running an operations. They're not concerned about every specific meal period or rest period. But unfortunately, that is the only way to avoid a class action. And what I usually recommend to our clients is to conduct audits, regular audits of their payroll practices, whether it's depending on the size of the operation, on a monthly basis, on a quarterly basis, or even on a yearly basis. But obviously, I prefer a quarter basis, but to make sure that they are in compliance. And like you mentioned, Nicole, another thing is that we have great technology now. And there's little things that the employers can do to be able to comply with that, with the requirements of the labor code. For example, nobody should do any rounding anymore. Even though rounding is allowed by law and still is, given the technology that we have nowadays, they should pay for every single second, minute that the employee is working. Otherwise, you could have a class action based on rounding, because the other option is to ensure all the time that your rounding practices is not benefiting the employer more than the employee, which is time consuming, it's difficult to do. So I say no rounding whatsoever. Second, other things that employers can do is they talk to the people that provides them with the timekeeping systems. You can have things like nobody can clock back in unless they've taken a full 30-minute lunch. That alone will take care of half of your problems. Or just little things like that. And something else that I also don't, that I advise my clients, do not try to keep track of the rest periods. Do not do it, because nobody does it properly. And
Right.
what ends up happening is that now there's a record of non-compliance.
Right.
So quite the opposite of what you need. So yeah, do not keep track of rest periods. Talk to your timekeeping people to see how many of those little things you can set up to help you be 100% in compliance with the labor code. And so many times I even have clients tell me, but I thought that the Brinker case said that we don't have to be the meal period police. That is not true. You still need to be the meal period police. It is true in theory, but what happens is that now you can find yourself defending a class action to show, and you're going to have to prove the reason why the meal period was not properly taken, and you don't want to be in that situation, because that means you're going to have to settle for a significant amount of money.
Yeah, and the other space too, just to note quickly, and I know we have other stuff to get onto, and Roxana, we could all probably talk about this.
Yeah, I know. 4 hours. We can put up class actions alone, right?
So, yeah. So a lot of our, we do a lot of HR assessments and on our consulting side, and one of the things that we come across a lot is the exempt versus non-exempt class misclassification in that space, which then of course triggers the wage and hour and all of those things. And so again, circling back to job descriptions and doing a job analysis on what does this person actually do, and just because you manage a process does not make you a man, you know, all of those little things really help set you up for success in that space. And so I know that exempt for a lot of employees seems very attractive, because it comes with, you know, feels like a status thing. And but really in terms of the protection of the employer, and even to the fairness to the employee, which is really the balance there, You just have to be mindful of those laws and really do the right thing in that space too. So that's the other piece that we see.
Yeah, no question about it. I mean, I can say very quickly two things. Do not have independent contractors. Extremely difficult to do nowadays. Most likely, you cannot have an independent contractor. Okay. And second, unless you have very clear indication that the employees are properly classified as a salary exempt employee, if there's any doubt or any gray area, you're much better off placing them as hourly employees. That's the safest way to go about it. And that's, that's, just remember those things. No independent contractors, and try to minimize any salary employees, and err on putting them on hourly versus exempt. And there's ways of selling it to the employees. As you said, Nicole, is very true. People see it as a status thing, right? Oh, I'm a salary employee now. But there's ways of putting it forward to the employee for them to understand that they're really better off being an hourly employee, and you avoid having the risk.
Yeah.
Yeah, that's a really good point, is that, those are some pretty easy things for us to address. 1099s after AB5 in California it's we should just stay away from it unless it's really crystal clear. But I think what we'll move on to now is, and we're really kind of talking about this already, but fraud factors and the increasing cost of nuisance claims. So we talked about claims that are really easy for class action, wage and hour, improper classification, that's like low-hanging fruit. However, there are other factors that are slightly more nuanced. And so maybe Jeff and Malky, you could give us an example or talk a little bit about what you're seeing in the industry in terms of these types of claims that if we put the right processes or practices into place, we can hopefully avoid them.
Yeah, the big part of the fraud factor on the EPL claims is investigations. I've seen quite a few of them last year. I've seen one this year with my clients in particular. The investigation piece is basically what's going to help the employer and the attorney and the HR to figure it out and get in touch with the adjuster and advise real quick. You need to work with your attorney, your HR person, to investigate any incident or alleged incident immediately before you even talk to your broker. This is step one. We had a particular case where there was a harassment claim made against an employer, and part of the claim indicated, and Roxana, you might be familiar with this one because it's a mutual client, so I'm going to try real hard not to say the names, but part of the claim indicated that the employee on their way, just to give this is not exactly what happened because I'm trying to change the story. Let's say from their desk on their way to the restroom have to pass by the president's desk, and there's always some type of harassment situation from the president towards the employee. Well, once it was investigated by one of Roxana's colleagues who physically went down to the office to take a look at it, it's not physically possible. There's no connection between where the desk was and where the restroom is in relation to the president's desk. So it was a pure out and out fraud claim. We've seen situations where demand comes in for $50,000 for many different claims. Investigate, turns out everything's false, sells for $700. That's an actual case on one of my clients. Settled for $50,000 demand, settled for $700. So yeah, investigation, getting in touch with as many people as you have in your circle is critical.
No question about it. If I may add, I have to agree with that 100%. The investigation piece of that is so, not only is key, but it's actually, when it comes to sexual harassment cases, it's required under the law. Employers are required to conduct an immediate and thorough investigation as soon as they have any knowledge or any notice of a potential sexual harassment claim. And then that is because that comes from the actual law that actually requires employers to prevent sexual harassment from happening. Most people, we assume that obviously we have an obligation to stop sexual harassment, right? But it's actually broader than that. The law requires that the employer prevent sexual harassment, and that's why that investigation is so key whenever somebody has any knowledge of a potential sexual harassment claim. No question about that.
What are some of the other situations where an investigation is required?
Any type of discrimination claim, where there is sexual harassment, or discrimination based on race, on age, any claim under the FIHA, retaliation, really requires an immediate investigation. And you want to be able to get statements from people, preferably in writing. Something that happens very often is that people leave and then you cannot communicate with them. So you want to get all your information just in case you may need it later on. And something to keep in mind is that if the accusation, let's say a sexual harassment accusation, is against somebody in upper management, you probably want to have your attorney involved in doing the investigation in order to have the attorney-client privilege applied to that investigation. Now, granted, if you end up in litigation, you may want to disclose the investigation because it might help you out, but you want to have that option of having the protection of the investigation if you're dealing with an upper management person.
So maybe Jeff, you can answer this one. As we've moved into a lot more of hybrid and remote work, are we seeing more fraudulent claims because we don't know what's happening with our employees when they're not on site?
We definitely are. I see them more personally because I have a lot of construction clients, and a lot of times it's wrongful termination. Even this crazy stuff where an employee is gone for numerous days, so they're automatically terminated. I think it's up to 3 days in California. And then they come back with a lawyer, and that lawyer just starts digging in, and they find something. And a lot of times it is the meal breaks type things, or their 15-minute breaks where they find a little thing in there. And that, what I consider fraudulent, the wrongful termination that was legit, turns into a lawsuit. I had one recently. It was a $250,000 lawsuit. They ended up settling it for $25,000, but it turned into that lawyer calling 3 other employees. And now they had 4 lawsuits going at the same time. So when you have a $25,000 retention on a policy, that's $100,000 right there if all of those just settle for $25,000. So that's where, not to go back to where we were earlier, but that's why the culture is so important, because these people come in and other people see they can get some money and then they start throwing lawsuits out also.
That's so true. If I
had
may,
a client where they were a fully remote, and one of their employees, they were trying to get a hold of them, email, phone calls, all of the mechanisms, and it was kind of a no call, no show, disappear for a week. And the client was kind of worried about the employee, and they did make the choice to terminate the employee, and the employee was really shocked. which is interesting. It kind of goes to your culture, Jeff. There, even if you're sick or or something's happened, communication in this day and age, it's pretty easy to send a text or
I think the reason why we're seeing so much increase in litigation now is twofold. One of them is just the new culture where people don't want to recognize that maybe they were not meeting the employer's expectations. So everybody thinks they're wrongfully terminated. And second is the fact a couple of years ago, there was a statute that was passed that allowed employees to provide the authority to request their files to an attorney, to a third person. So what we see now every day is letters from attorneys asking for a copy of the personnel and the payroll records on a regular basis, right? Sometimes they may move on to litigation, sometimes they may not. Sometimes we settle them for a couple $1,000s before they even go to litigation. But it's made it very easy for the attorneys to be able to request the file of the employee. So every employee walks in saying, I've been wrongfully terminated, right? And the attorney may say, no, there's an at-will state and they have the right to terminate you, but let's take a look at your file and let's see what else we can find, right? And usually it leads to the wage and hour or some other claim, like maybe harassment, oh, you don't seem to have the proper policies concerning sexual harassment, or you don't seem to have the proper policies concerning a FIHA retaliation claim. So that opens up, there's Pandora box where they can file a claim. So what we see all the time, and my clients know this, if they terminate somebody, they're either going to have a workers' comp claim or they're going to have some kind of claim, a wage and hour, or some kind of discrimination or harassment claim. Because I get it, nobody likes to be terminated, but nowadays it's such an expectation that you cannot terminate me that they're going to go see an attorney. And we all know there's no shortage of attorneys in Southern California. There's one in every corner, so no problems there finding somebody.
Yeah, I wanted to mention also, circling back even as we talk about, you know, we've all recently been through a global pandemic, and we're all coming out on the other side of that really interesting time period. And so I think what we're seeing also on our side is people have not fully pivoted to, okay, we were forced to be remote and now we're intentionally remote, and being sort of mindful of, so they're trying to adopt the policies that they had prior to and just continue on, as opposed to pivoting those policies to understand the implications of, as we're with companies who are moving into hybrid, moving into remote workforce, and then also multi-state. Now we're allowing people to move into multiple places. There are a lot of considerations from a model, a business model, and an organizational design perspective that need to be considered when we begin to make those business decisions. And so it's not just the risk insulation component. That's certainly one piece of it. There are a lot of business impacts that need to be considered when we begin to talk about growth modeling and all of those things. And as we shift that kind of modeling, understanding just on the compliance, the administrative piece, but then also what's the business impact of all of those decisions. There's a lot of those things that need to be considered as well internally with your teams.
But it's tough to track sometimes.
Question,
I mean,
Roxana. If someone is to get sued, and maybe this is a Malky and Jeff question, on your EPLI policy, do you have the ability to pick your own legal counsel? Because obviously you want to get representation as soon as a claim comes up.
That's a fantastic question. If you asked me this 12 years ago, I would have said, yeah, absolutely, you can pick your choice of counsel. Today, not really. Choice of counsel is very, very hard to find. It's becoming more and more limited. And I'm talking about companies that are not Fortune 500 companies. I'm talking about most of our clients that are in the 50 to 1,000 employee range within that category. It's almost impossible to find. I had 6, 7 years ago, I had 5 carriers that would offer it through a great partnership I have with one of our wholesale partners. Now we're down to 2. It's really hard to find, and they won't just let you appoint any counsel you want. It has to be somebody with a long-standing reputation in this arena that's not playing both sides of the coin, plaintiff and defense work, strictly on the defense side. Landegger, Verano, and Davis is a perfect example of that. All they've done is employer law and employment law strictly on the employer side. So it was an easier conversation for me to have with the underwriters and my wholesale partners to get that done, but it's almost impossible to get. You're stuck with a panel counsel.
So what is the process if an employer has an employee that is threatening to sue in terms of EPLI? What should an employer do?
For me, always the first step is call your labor attorney. That's the first step before we put in a claim, to see if there's even a claim. A lot of these are not claims. A lot of these are settlable outside of insurance, small nuisance claims or whatever the case may be. Step 1 is always call your labor attorney, and not your corporate attorney, specifically your labor attorney.
Mm-hmm.
Corporate attorneys dabble in areas of labor law.
I had a good one the other day. Somebody said if you have a good labor attorney, they can pretty much be your corporate attorney here in California. So labor attorney is so important, because if they can do labor law, they can do it all here.
Yeah, I have horror stories where I have clients that have, their corporate attorney try to negotiate some kind of settlement of a pre-litigation claim, and it just turns into a nightmare. I had one that was trying to settle a class action, and that was interesting. Needless to say, it did not settle until they came to us. But very often what we see a lot of right now is a lot of pre-litigation demands, which is good for the employer because it gives us an opportunity to get in there and try to resolve it very quickly early on. As far as nuisance value, though, we have seen a big change. I used to say nuisance value was $30,000, $40,000. Now we're seeing nuisance value at $60,000 to $80,000, close to $100,000 for just any minor case. It really, I always say, in any litigation, it really comes down to putting money in the pocket of the attorney. And attorneys are not walking away unless they get at least 30,000 or 35 in their pocket. So that's why we're seeing the increase in nuisance value cases. And I can tell you that having EPLI insurance is so helpful to our clients when they have discrimination or harassment claims. And every time a client calls me with a potential claim, my first question to them is, did you have EPLI insurance? And 8 times out of 10, the answer is, what is that? And I have to explain to them what it is. I say, talk to your broker. Let's see if you have it. Because that's going to make a difference on how we approach the claim, including what the amount of the deductible is, right? If we think it's a claim that we can resolve within the deductible, then there's really no reason for them to submit it to the policy, because we can get rid of it for the same amount of money. So yeah, there's a lot of factors there to consider, but EPLI insurance has been amazing for our clients, including for wage and hour. Even though it does not cover the settlement, sometimes it will provide defense costs, and we're able to resolve the matter within the defense cost.
Yes, I know that Nicole and I, when we're out at engagements together, are looking at risk management, and from a finance and human capital side, the EPLI is one of the things we evaluate almost immediately, because if there is none, we want to tackle that really sooner rather than later. Do you guys have a sense, as we go into clients, about the market for EPLI right now? What are the costs looking like?
Yeah, the market's shift. I don't want to say shifted. Shifted is the wrong word, because shifted usually means some significant change. The market's pretty flat for the most part in California and outside of California. The 3 problem states are California, Florida, and New York for EPLI. Those are the big states where most of the claims happen. We're seeing flat renewals on clean accounts meaning they haven't had any claims in a year or 2. I had a surprising renewal last week on one of my clients that actually had a claim, and the renewal still came in flat. That never happened, in the last 7-8 years. But it's happening now. There's more capacity. There's more syndicates coming into the market, so the capacity is increasing, which is a good thing. But the rates are flat, retentions are still high, especially in California. They're going higher if you've had a claim. If you've had a class action wage and hour, you're not going to get the sublimit for defense moving forward. It's like a 1 strike and you're out for the most part.
Oh, wow. Okay. So it is really important to have our policies in place. And so I know you touched about this a little bit at the beginning of our conversation, but I just want to reinforce, do you have EPLI coverage on any other policies, or do you have to get a separate coverage altogether?
Yes and no, the proverbial answer. You can, if you have what's called a BOP policy, a business owner's package for a small business. They might include, depending on the carrier, 15, 20, 25,000 of EPLI coverage, but it's very limited. And it has a lot of exclusions on it. It's not recommended. You're always going to be better off getting your own.
Okay. I have a question in here, which is a very interesting one. This client says, I use a PEO, and the PEO includes EPLI. Should I still carry my own?
That's a great question. Yes, most PEOs will force you to get EPLI and pay for it. They charge per employee per month for it. The problem with PEO's EPLI is it's kind of structured to their advantage from a couple of different ways. The retentions are super high, 100, 125,000, 150,000. When you get it on your own, you can get as low as 25, 50,000. They do not cover third party. There's no way they're going to cover third party. And if you joined a PEO, let's say within the last year, you have a claim come in from an employee that you terminated before you joined the PEO, you're not going to get coverage for it. So all our clients that are with PEOs, they have separate EPL policies.
Okay.
Yeah.
And if you're on a PEO, just from an internal controls process, I'm assuming that the process is the same. If there is a potential claim, you call your labor attorney first. But then I suspect if there's an issue, then you loop in the PEO and your broker at the same time. Okay.
Correct, because they're the co-employer with you, so you're obligated to notify them if there's an issue.
And that's a good subject because PEOs use that, a lot of them that sell directly to clients. They're going to say, we include EPLI, we can save you money on your EPLI, and they don't explain what's actually covered and why it's not advantageous to the client, but to them. So it's good if I would recommend if you are in a PEO or going a PEO route, still have a broker involved because most brokers have numerous PEOs they work with, and they can still be your advisor through that process and not let a bunch of PEOs just try to sell you on their program based off of the EPLI and all that stuff. It's good to have an advisor to look at that.
That's really, really helpful. So,
yeah, and I just wanted to touch on that point in terms of the internal from an HR perspective as well. I think oftentimes there's misunderstandings about what our policies include and don't include, and it's almost like this chicken race, right, between the risk happening and what the insurance policy we have in place. And because we are not actually diving in with our brokers to have real meaningful conversations about, can we walk through some examples of what would not be included, what would be included, and really having a very firm understanding of where we're protected, where we're insulated from risk and where we're not, and then having those conversations will be critical in terms of leveraging your partners correctly.
Yep.
And so who do you usually see doing that with your clients? Is that the chief people officer? Is it the HR director? How are you all seeing that, you know, when you're interfacing with clients? Or is it the finance person and they should be looping the HR folks in?
It depends on the client and how they're structured, whether they have an internal HR team or not, or they're using an outsourced HR. For us, Jeff and I, the way our business is structured differently. We don't market to the general business public. We work on referral only. So it's trusted advisors that bring us into their clients. So our conversations are 90% not related to insurance and 10% about insurance. We want to know, how is your onboarding process? How's your hiring practices? What are you doing here? What do you do? We ask these questions because we can't really mitigate and you know, take care of your risk because we don't know what you're doing. Just to slap insurance on there and say, oh, all else fails, you have insurance, that's not a solution.
Yeah.
So it could be the HR director, it could be the CFO. A lot of times with the larger companies, it's the CFO that we're dealing with. My larger tech clients, I deal with their general in-house counsel. So it depends on who we're having the conversation, but we're always having those conversations.
Thankfully, you're asking the questions and guiding, you know, your clients through the process. It's very helpful. I know Nicole and I, you know, we partner together as a CPO, CFO, often on clients, and so we can manage the risk of all of the aspects of the business. And really value, you know, partners like IOA who are asking questions that you're in the field, you're seeing things that are coming up that we, you know, that we wouldn't have imagined maybe, you know, a few years ago. So you can ask those questions and we can proactively address policies, new laws, all of those things that are important, particularly when we're dealing with California, New York, and Florida. And we definitely see the changing landscape of California employment law on an ongoing basis.
The other thing too that I think is the benefit of having your finance teams and the human resource teams partnering together is that, you know, all of them are interconnected, right? With the financial impact, the risk insulation, the policies, the people experience, all of those things. And so, you know, Jeff had mentioned earlier about some of those. I know today's discussion is specific to EPLI, but, you know, as we talk about workers' compensation and the other types of insurances, they all sort of interconnect because typically if you're having significant comp issues, right behind that is that ER issue that's coming in, that employee relations issue that's coming in. Sometimes that's the driver in terms of exponentially raising those claims, right? The stakes to all of those claims. And so a lot of it is partnering the people side and the finance side together. They have to work lockstep key. So, you know, that's one of my favorite parts about working at PBO is that, you know, from a finance and a people perspective, we look at it from both lenses. And I think whether it's an outsourced team or in your internal team, I would highly recommend both lenses. It provides the most value to your organization.
You know, I mean, at the end of the day, we're businesses, right? And the people make these businesses go, but we also have a fiscal responsibility. So they're both equally important. I guess, Nicole, what are some of the other roles you see as you go into clients and talking about what is the role of the risk manager, whether that's us or whether that's someone internally at the client side?
Yeah, so I think that part of it is, again, you know, Malky had mentioned sometimes it's the way the organization itself is developed, right? And so I think sometimes what happens when we go into clients, it's sort of having a firm understanding of the talent that currently sits within that organization in terms of, do they really understand the risk piece, how to mitigate it? So are we operationalizing our safety, for instance, in a proactive way? Are we reacting to things as they come up? And so we're fixing things on the back end when that rock is picked up and looked under, and then it's, oh geez, we should write a policy around that, or we should do those things. So in terms of the risk piece, what I would say is that the majority of human resources teams are really not trained in the risk space as part of a generalist. That's been my experience. HR generalists, they'll transact claims, but they're not necessarily acutely aware of the bigger picture component. And so if you are a smaller organization and you have an office manager that was trained to become a generalist, or you have a generalist that comes on, there needs to be a managed expectation about what that person can, you know, deliver in terms of impactful. And so while of course we want to continue to, you know, develop and give everybody exposure and set them up for success as well as they have a learning curve, I think what will be critical is surrounding them with the right resources and teaching all of our internal teams how to cultivate the right relationships and resources with our attorneys, when to call the attorney, when to call the brokers, and leveraging your talent around you to really help, you know, bring to that space what needs the gift of sight for visibility. So on our side, we partner with the risk managers, whomever that might be, dependent, right? If you're a construction industry, they're going to be really high octane safety. And so we understand then how to pivot and partner with them. And then on the back side too, you know, whether maybe you're a consulting firm, so you're in office, or it's not as, you know, your concerns are different. So it's really sort of understanding your business model in general and where are you going to have the higher impact from a concern perspective, whether it's, you know, for instance, I-9 audits, probably not going to be a high risk area for consulting firms. But if you're in manufacturing, like, you may have a different lens in that space. So it's sort of understanding your business model, the industry as well. But more importantly, in terms of your teams, and the most important piece is setting them up with the right environment, resources, and tools for that team to be successful.
So Roxana, if you were to, you know, talk to your clients, what are some of the very simple things you could tell them that would be good for mitigating risk?
Okay. The first thing that I would check with them is to make sure they have the proper documentation for each employee. That's number one. Even if they're not, I'll send them a whole package to say, okay, I want all your employees to sign these documents today, to make sure they have all the required policies, they have the right policies to communicate what the employees need to do. And second will be just regular audits of the payroll records. That is definitely the most common claim is the wage and hour, and they are very expensive to settle. These wage and hour class actions, PAGA, are not inexpensive to settle because of they can recover both statutory and civil penalties, and that's why they make them so expensive. So that would be my two primary recommendations. A third, it would be train your management. Train your management, of course, depending on the size of the employer, but train your management to be in communication with the employees, and that is key. I'm always surprised when somebody has a sexual harassment claim or some kind of harassment discrimination claim, and management is completely oblivious to the problem. I always say, if you have a good manager and there's issues in the workplace, the manager is the first one who should notice something, whether it's talk or conversations, people being unhappy, and there has to be some kind of active response from management to try to find out what is happening. Which leads me to, another issue that we deal with very often, and not extremely often, but we're seeing some activity recently, is unions. Unions trying to come into the workplace, and that is because employees are not happy. Employees will seek a union when they're not happy. So why is it that management is not aware of that? So I would say management training would be my third recommendation to every employer.
Yeah, that's a great point.
It's a really good segue. Nicole, do you feel like it's the HR's responsibility to kind of manage that and oversee that, or whose responsibility is that in the organization?
Yeah, so I think a few points in terms of, so circling back to Roxana's previous point with respect to management training. So another inflection point in the employee life cycle is promotion. And oftentimes we promote managers because they have a really solid technical skill, but they're not equipped for soft skills or leadership skills yet at this point. And so remembering that they are your front line of defense in that space, they are going to be either the people who see it first and or are expected to manage it. And oftentimes with organizations, we just say, well, you're a manager, you should be able to know how to deal with this situation. And so setting them up for success will be really important. The second part to your question about the internal team, whose responsibility is it? Often people think human resources is supposed to play the role of police. And we get to police the policies, and we get to police all the people and the managers. And what I would say is your human resources team, when operating effectively and efficiently, really is meant to be your partner. So we're meant to be your subject matter experts in the policy. We're meant to be your subject matter experts in helping guide you have these conversations. And so doing right by the organization from a culture is everybody's responsibility. And when the leadership team is table setting correctly, everybody understands the value set and what the leadership's expectation and value sets are and how we behave in this organization. When that's set correctly, human resources really, when used appropriately, should be the partner in that space to help managers navigate and not the ones who are doing the policing themselves. So it's a group effort, but often human resources somehow gets put on the police cap. But quite frankly, that is when they're in a reactive. If we're being proactive, then one of the signs of being proactive is that you're using us as a partner and not as the police. So, and you really want us to be neutral in that space, right? So employees want to be able to come to us easy and have a good feedback loop. That's also really critical to Roxana's point earlier, which was the communication piece as it reflects to culture. So that's what I would say I would look for in terms of how to partner correctly with your HR team.
I cannot believe that it's already 9:30. I've been enjoying this conversation so much, but I do know that our attendees have slotted an hour. So really, EPLI, is it worth considering in the current state of the market? I think I'll hand that off to Jeff and Malky, and maybe they can talk a little bit about how it's priced and how one would go about getting that insurance.
Sure. Is it worth it? I think after everything we heard today, yeah, I think it's worth it. The way it's priced is typically based on the industry you're in, the number of employees you have, where they are, how much they're compensated, and your claims history. That's typically the main factors they look at when you price an EPLI policy. However, I wanted to ask the question, is it worth it? Because I've had a couple of situations in the past year and a half with clients where, I'll give one example. They have 700 employees, a little over 700 employees. They they're on the lower end of the wage scale. So we're talking about slightly above minimum wage, under $22 an hour for the most part. It's a labor-intensive workforce. They've had claims in the past. The claims have all been smaller claims that have settled for $15,000 to $35,000. When we approached the market to get pricing for them, the pricing was in the $60,000 to $65,000 range with $100,000 retention. Then I started asking the question when I proposed, like, do you think it's really worth it? I asked the client, do you really think it's worth it? They're like, I don't know. What do you think? I go, look, I'm not going to sell you something just for the sake of selling you something. Talk to your labor attorney and get back to me. And they came back with, you know what? We're not going to do it. I'm like, I get it. I totally get it. They're, of course,
Yeah,
at risk
that
of
makes
class
sense.
action
It's
cases,
good to
but other than that,
evaluate from all aspects, for sure.
Yeah.
you have to, yeah. It's like I said earlier, it's not a matter of just slapping insurance on the problem and moving on. There's a
Right.
lot of factors involved.
Yeah, with the retentions going up, it's so important to talk to your broker, your attorney, HR, and really understand what you're buying and do you really need it before you just buy insurance just to buy it.
Very good point. So with that, what I'd like to do is, since we're out of time, I was able to ask questions throughout, which was really helpful. I'll start with Malky. I'm going across the board. Everyone probably sees a different order, but I'll start with Malky, and maybe you could just provide a key take. Each of you provide a key takeaway from today's topic.
The key takeaway for me is build your team around you, whether it's internal, external, and have conversations. That's the best way you can mitigate your risk, is make sure you understand what's going on, the environment you're in, how you're addressing it before anything happens to avoid anything happening. That's my key takeaway.
Roxana?
I couldn't agree more. Have the right people in place and have those conversations about what is our culture, what do we need, and what's the best options for us.
And Jeff?
I would agree, just evaluate your current partnerships and make sure that your HR, accounting, your lawyer, your broker, everybody's kind of working together. They all have the same common goals to help you out. That's very important.
And last but not least, Nicole.
Yes, thanks. I'll close. So I actually agree with the entire panel. I think we can all agree, surrounding yourself when you get stuck and you don't know how to move appropriately and what to do. You know, there are a lot of resources for your teams. There are a lot of people that you can surround yourself with to make these types of decisions. You're not expected to be a subject matter expert. So you really should surround yourself with people so you can continue to operate your business. And then just surround yourself with the right team in order to help you insulate from risk and just think through, right? Is this right for us? Is this not? And even as you grow into larger organization, then we can begin to have some bigger conversation. At what point do we consider these types of things? So that's what I would say.
Very good. So for those of you attending the webinar, feel free to reach out to any one of the panelists. Their contact information is on the next slide here, and they can be your resources as we're navigating as employers. There are things that, you know, we're not subject matter experts in, and this panel here can really help you navigate through and make good choices and policies and procedures to be able to navigate being an employer in this marketplace. And thanks so much for your time. We appreciate it. We know it's very valuable. Thank you to Malky, Roxana, Jeff, and Nicole for joining us today, and have a wonderful day, and we'll talk soon. Take care.
Thank you. Have a nice day. Thank you very much.
Thank you, everyone.